for joining today's webinar. Today's topic, New York's revised cannabis regulation, what you need to know now to plan ahead and structure deals. I'll introduce myself and my co-panelists, and then we'll just kind of run a show and then get going. A lot of information to cover in a short amount of time. Do the disclaimer that we might not have all the answers, but happy to answer what we do know or what we predict or think might be coming, with the caveat that, of course, none of this is legal advice, and you should actually speak with your own legal counsel to get, fact-specific inquiry, but happy to answer what we can here. Next slide. So appreciate everyone who's able to join this Vicente webinar, and just a reminder of our offices across the country, including one of our flagship offices in New York. Next slide. I'll just do a brief introduction. My name is Michelle Bodian. I'm a partner at the firm, and I am a key player in our New York market as well as in Connecticut, and co-chair of our national hemp department. I'm going to kick it over to Elliot to introduce himself.
Hi, everybody. I'm Elliot Choi. I'm corporate counsel and chief knowledge officer here at Vicente. I'm also a native New Yorker, so the New York market and its rollout is personal to me, in addition to professional capacity. And I'll flip it over to Charlie here.
Hi, everyone. Charlie Alovisetti here. Nothing particular to add. Just looking forward to talk through what is a pretty complicated set of rules.
All right, and we'll be kicking all the corporate questions to you, Charlie, on today's webinar, since you are a chair of the corporate department here. So I'll talk you up even if you're not going to do it. So quick run of show, what we hope to cover quickly, and we will leave time for questions at the end. There's both a Q&A function on the bottom and a chat. If you funnel all your questions into the Q&A, we're more likely to answer them, but so please use that button in that function. So quick update where we are. If you know nothing about New York and stumbled your way into this webinar, we want to give you an update of where licenses stands, the latest stats of everything. Want to touch briefly on the enforcement legislation and some pending legislation, since obviously that's going to impact the rollout of the market. Then, the actual topic du jour, talking about the revised draft regulations. So talking about what has changed from the first draft to the second draft. And then more specifically, and where Charlie and Elliot will really shine, is talking about how the new regulations will impact capital raises and M&A. Then we want to talk briefly about the anticipated timeline for adult use applications, just kind of briefly touch on the license types and some canopy tiers. Then just a little information about how people in other markets can get into this market. And then there's some just like fun, in quotes, some fun information about some other licenses you're going to need in order to do certain operations in New York. Next slide. All right, so Elliot, you want to give an update?
Yeah, sure. So recently there have been kind of two big developments in New York in addition to the kind of revised regulations. Recently the governor here passed the 2024 budget, and included in one of the provisions in the back is enforcement legislation designed to combat the illicit shops that we've seen proliferate all over the state, and in particular in the city here. So among other kind of enforcement mechanisms, there's increased fines, including fines for landlords. There's an inspection right for both the Office of Cannabis Management and also the tax department. And then there's the ability to implement permanent injunctions to hopefully close these stores and not allow them to reopen. Because I think we've seen a lot is that the products get confiscated and then the very next day they're restocked and open again. So hopefully these permanent injunctions kind of stop that. And we all know how important it is to kind of get these illicit dispensaries effectively under control here in order to allow the legal market to flourish. There have been a few cannabis-related bills proposed in the state government here, but one that we think has a little bit of legs is the Cannabis Crop Rescue Act, and this is the one that would allow the adult use conditional cultivators to sell cannabis products directly to consumers, via farm stand type of structures on the farm themselves. And then this also allow for loans and grants to allow the cultivators to process their flower into distillate. And this is designed to keep that product in a viable form since it's been sitting around for a while. Next slide here. And Michelle will take it over here.
Yeah, and one other thing we did not include in the slide, which obviously dovetails to some of this enforcement and crackdown of the illicit market, is just the intoxicating hemp products that have proliferated the entire US, but in particular in New York. So we do anticipate, and the state of New York has said they'll be coming out with emergency regulations, most likely in June, in time for the June Cannabis Control Board meeting. So those regulations, not sure exactly what they're going to say, but the idea we speculate is that if if a store gets their, marijuana product seized, they're not going to be able to turn around and say, just kidding, this is actually a hemp product or a hemp derived product in order to keep it on the shelf. So we do think this is going to work in concert to really have a, an effort to shut down those stores in that market. But to be determined once we see what those regulations actually say. All right, back to the slide actually at hand. So just quick update on the stats. So as everyone knows, we had conditional cultivator licenses and conditional processor licenses. Just a reminder that those applications are not open. They're not going to open, but these are the existing operators in the supply chain. And to date for cultivation, 278 licenses have been granted, and for processing, 42 licenses are granted. And licensing granted does not obviously equate operational status or what products are being made by these licensees, but at least the idea that these licenses exist, they're out there and they could be operationalized if they chose to. All right, next slide, please, for Charlie.
Yeah, so this is just the conditional adult use retail dispensary license. I saw a question, someone had dropped in about, the revised rules and how it addresses convictions. If it was respect to these CAURD licenses, that window has shut in terms of the application process. They're expecting to do 300 total. From the perspective, as it ties into the rules here, what's interesting is that there are a few places in the rules where it specifically overrides the CAURD rules, right? Which are the only rules that really came out so far with respect to adult use businesses to date. Because for the grows and the processors, you've got FAQs, but you didn't necessarily have rules. So when you're going through these rules, they had to take out some of the CAURD provisions when it comes to these corporate concepts like options and warrants. Next slide. All right, these are just these are the list of some of the stores that are open, right? Obviously, the fact that we can put this on one screen tells you something about the status of the market right now. So that's the market right now. You don't have a ton of regulated stores open. Obviously, this is a fraction of the total number of stores open in New York right now. The vast majority of which are illicit. Next page.
Yeah, and so just giving the overview for right now for CAURD, we have 278 licensed. They're hoping to get a total of 300. The state had said that, but for the enjoined region, all the other licenses should be awarded at the next, several couple meetings. And then from that, there are 9 stores that are currently open. Just to summarize the slide before we move on to the number of labs that are operational.
Okay, so people can see the slide. So labs, yeah, I mean, not a ton to add here in terms of what's operational here. They do have when it comes to corporate stuff, right, which is just the kind of the lens of looking at this stuff. At with respect to the labs, it looks like you had a 10% materiality threshold. When it came to disclosure, which we're going to talk about when we get to it for the rest of the adult use regulations. It'll be interesting to see if it follows the same approach. I don't think it does, but there's an argument it does, which it's just sort of setting the stage for the confusing aspects of how this is actually going to play out. You've got a number of licensed labs right now, with its 14 labs, and then there's sampling, which is different from labs in New York. I think we go to the next slide.
All right, so we had the first set of adult use regulations, at least the complete set, published on December 14th of last year, and that started a 60-day public comment period. And Vicente, along with the various organizations we're part of, including many of the participants that I see join this webinar, provided a bunch of comments. We understand there are about 5,000 public comments, which the OCM has been did review and then revise the regulations. Next slide, Guillermo. And so they just on May 11th approve the revised regulations. We expect them to be published on May 31st in the Register. That publication will trigger another 45-day public comment period. And the expectation is that will be the final public comment period, and the regulations will be final after that. But we'll kind of see on that. The major changes, which we'll go in more detail later on, they had updated provisions around the true party of interest, TPI, and passive investors, and what qualifies as such, and also what they can and cannot do. Environmental and sustainability targets for licensees were also changed. The registered organizations, which for those not familiar with New York, are the vertically integrated medical operators currently here in the state. They've included a mechanism that allows for them to convert into the adult use market. They also implemented regulations around third-party technology platforms, essentially kind of market aggregators that we see out there in other states. And then also they actually added in a bunch of regulations around on-site consumption for retail licensees. So that was something they shoehorned in. Next slide, Michelle.
Great, thanks. And I think we had a question about whether the slides will be available after the presentation, usually within a couple of days. We'll email out a recording for everyone who wants to watch this over and over again, as well as have a copy of the slide deck available. So we touched on the timing Elliot did about these regulations, and the reason we're essentially calling this second draft effectively final, even if not actually final, is because the state has said they plan to open up new applications in the fall. The latest phrasing has shifted from the general fall to now after Labor Day, before the end of the year. So given where that falls, we're assuming that means mid to end of October. So a nice application, a nice Halloween application round is what we're anticipating. And so if you work backwards from that date, in order to have final regulations in time, and in order to get all of this done, that means between now and the final publication in August, they're only going to be able to make a few minor changes. And even at the last Cannabis Control Board meeting, staff had indicated, even if they want to make more changes, what they'd most likely do is publish this version as final in August, and then immediately start working on redrafts and redrafts and redrafts. And I see a few questions rolling in. We will have time for questions at the end, but I'll take this one right now with the next slide if we want to move on. But essentially, we don't yet know what applications are going to be opening up in the fall. We don't anticipate it's going to be all license types, at once. We anticipate it's going to be some type of rolling process where, possibly, and I say possibly, don't hold me to this, possibly micro businesses would open up first, or beginning of the supply chain, so additional cultivators or processors, but doing it in some type of staggered approach. But my prediction of Halloween, come Halloween day, I don't see, all licensing types opening up. But what we do know, there'll be set applications periods, and this is in the revised regulations. They're going to be announced at least 30 days in advance. So possibly, after Labor Day, October 1, they give you 30 days notice, get organized, get ready. We caution you not to wait that long, but they'd at least give you 30 days notice before the application windows open. And then in terms of what the applications are going to look like, how they're going to be ranked and all of that, we don't have a ton of information. We're hearing it might be kind of a general application where it's some set of information you answer for all types of licenses, and then you check some additional boxes depending on what type of licenses you're doing, kind of reminiscent of the college common app. So they are looking to streamline it, but presumably it's going to be similar to these conditional licenses, all online through the Business Express portal. And then the state of New York can put limitations about the total number of licenses they can do. They can do regional awards like they did with CAURD of, chopping the state in sections and saying so many licenses in so many regions. So they've really built in these regulations a lot of flexibility of what this is going to look like. And they're kind of hedging because it's clear they haven't yet decided, but giving them the authority to figure this out. And then we do know one change, that you'll be doing a provisional to final license approach. So if you don't yet have property, you would be allowed to apply for a provisional license rather than needing to come in the application with property locked in. We don't yet know, ultimately if they do some type of ranking or scoring criteria, we don't know if you would rank or score higher if you did have property, but that is a change, making that provisional to final license process a little bit different. Next slide. All right, now the fun stuff.
All right, so for those not familiar, the true party of interest, the reason this is an important defined term here in New York is that TPIs of licensees are subject to essentially a cross-tier ownership restriction, meaning that if you're on the retail side as a TPI, you can't be on the production side, meaning cultivation, processing, distribution, and the like, and vice versa. So this is a pretty kind of restrictive to term here, and we were hoping to see an expansion. I mean, sorry, a little bit more flexibility into kind of what qualifies as a TPI. Unfortunately, there weren't too many changes to this definition in the revised regs. The change there, as you can see, is the change from the 100K threshold to 250K. Essentially, this 1050, what 250K rule is if you get 10% of gross revenues, 50% of net profits, or 250,000 in any calendar year, it makes you a TPI. It doesn't matter kind of why you get those amounts, but if you get those amounts, it makes you a TPI of that licensee. Other people that qualify as TPIs are people with controlling interests, including certain officers and the like that are delineated in the definition. Anybody with the share of ownership, including up the corporate chain. So that's pretty expansive. And then anyone with a financial interest, which is defined essentially as anyone with a future right of ownership. So anyone holding a kind of a convertible instrument would consider to have a financial interest, even if they don't have any ownership today. For the one thing I forgot to mention on the 1050, 250K rule, if you have multiple agreements with the licensee, they're stacked, meaning that you look at them in the aggregate, not individual. So, trying to have multiple agreements to get below those thresholds isn't going to work in the New York regs. Another important aspect of the TPI definition is that for people with controlling interests, any stockholders, and then any person with ownership up the chain, all those spouses also qualify as TPIs. And being a TPI, in addition to being subject to the cross-tier ownership restriction, you're also subject to disclosure and background vetting by the OCM here. So it's just important to keep in mind. Next slide, please.
Yes, just I was just a few other points like with TPI is that based on the way the rules are drafted, if you somehow, which by the way you're not going to be able to do, but if you somehow manage to get a legit PE fund to invest in your New York license, right? And CalPERS, the California Retirement Fund was an LP in that fund. Technically, like almost every 10% of the state of California would be considered a TPI in your license under the sort of a black letter read of the rules. So, this stuff can get pretty expansive. And, the other thing with the TPI, right, is for the retail dispensaries, it applies for out-of-state ownership too. So, you can't, you can't be crossing the two tiers if you're a TPI in a retail dispensary in New York. So
yeah, said differently, if you have an interest in a retail dispensary in New York, you can't be vertically integrated outside of the state. So it's pretty prohibitive. So any vertically integrated operators outside of New York can't really invest or have an ownership in a retail dispensary in New York State.
But they'd be able to come in on the cultivation, processing, distribution tier. So you'd have an opportunity in New York. It might just not necessarily the one you're most excited about.
So related to this discussion, they did have materiality thresholds for disclosure. Now, this is what gets disclosed in the application. This doesn't mean that just because you weren't disclosed doesn't mean you aren't a TPI. This is really just what gets disclosed to the OCM and then gets put through their vetting background here. So as you can see, you have to include a cap table with your application, and for privately held companies, there's a 10% threshold, and for public companies, there's a 5% threshold. So, the regulations here do try and address some of the practical issues we have around disclosing all of your owners, especially for public companies, which is virtually impossible to kind of give a definitive list of all the owners at any given time. And this is also we hope will make it easier for companies to raise capital, since these kind of percentage thresholds for disclosure is consistent with what we see typically in other states. Next slide, Charlie.
Yeah, so I mean, I guess the big caveat, this corporate stuff is going to be tricky, and you really got to have to talk to your lawyer about it, because it's curious to see how it actually works out in the practice, because we haven't done this in a bunch of other states, right? The other thing you actually take into account is what are the forms that they'll eventually generate look like? So if you're doing a change of control, right? So capital raise or M&A transaction, in most states where you've got a lot of activity, so like a Colorado versus a Florida, you got a bunch of licenses in the stands, they come up with a process, right? There'll be a form that you have to fill out. So what that form will look like, I think will impact how this plays out in reality. But the answer is, that there's perhaps a chance that the materiality threshold will apply. There is no materiality threshold when it comes to cross ownership. This is just a matter of sort of disclosure, which from a capital raise perspective is impactful because if you're trying to raise money, your investors are not going to want to get run through the regulatory process. So if you're able to avoid disclosing people below 10%, it's going to make it much easier to raise capital. Now, I just don't know if you're going to be able to do that. I mean, I think there is this one piece of the rules that says you have to have cap tables people 10% above, which is promising, but everyone else is still considered a TPI. So I could still see them requiring disclosure. It's sort of a wait and see and talk to your lawyer type situation. It's a difficult thing to give a clear answer on here. So in terms of capital raises, your TPI threshold goes up to 250K. And just to clarify, it's not a question about that's sort of from a lending perspective. That doesn't include the return of capital. It's just interest in a year. But you can see that it sort of caps the size of a loan a licensee could take on. Assuming that you've got like maybe a 20% interest rate in the cannabis industry right now. So it caps the size of loan you can take on without your lender becoming its TPI. Landlord and financiers are able to cross tiers, and landlord and financiers are still not subject to caps. But again, just remember that the financier can cross over into a TPI, but the landlord, it doesn't seem like the landlord, as long as it's a flat rental fee. If you start charging participation rent, you're going to end up as a TPI. M&A, the conditional licenses can't change at 51% owner while the licensee remains conditional. We also haven't seen like a process to change the remaining 49%. So there isn't a formalized M&A process. I also say it's hard to tell from the rules exactly how the M&A process will work in New York. But I mean, I would assume that you're going to need prior written approval from the regulators to close in the transaction, but it'll probably only be at the state level because there's not a separate local license.
And just to jump in here, we've been talking a lot about these tiers, and apologies, we're assuming some base level because this is one in a series of many webinars we've been doing on New York. So in New York, it is a two-tier system, the supply side versus the retail side. And so all the licenses have been assorted into buckets. If you're on the one tier, so cultivation, manufacturing, processing, that's essentially you're in the making it tier. And then if you're in the selling it tier, this is obviously not the phrases they're using, these are my phrases, the retail, on-site consumption, that is going to be its own tier. Then the labs are an outside tier. So every license is sorted and they want to make sure the downstream, the retail, aren't influenced by the upstream supply side for these two separate tiers. So two separate tiers, not supposed to meet.
Yeah, and the testing tier is, not supposed to have any cross ownership between testing and any other license, which is very common. I mean, you see that in almost every state. Actually, I'm not aware of any state where that's not there.
Appreciate the question. Thanks for having us hop into that.
So what we also have in the regulations, they have two different types of agreements. Previously, they had a management services concept, which has been removed. And instead, they kind of went with two types of goods and services agreements, exempt and non-exempt. Exempt essentially meaning you have no control or undue influence and you fall below the TPI thresholds. And this is trying to capture your kind of ancillary service providers, things that do not go anything to the plant touching services, including accounting firms, legal services such as Vicente. And this is allowed to cross tiers, again, subject to kind of the TPI threshold. So if we as Vicente actually receive more than 250K in fees from any licensee, we would then be a TPI those licensees and subject to all the cross tier restrictions there. There are non-exempt goods and services also defined in the regulations. And as mentioned, this is really kind of stuff related to the plant touching services. To just note that the way this is defined, it's consulting services related to these plant touching services. And so it seems OCM doesn't want people to directly subcontract out plant touching services and have, third parties come in and enter facilities. Again, this is also subject to the TPI restrictions. So if you go above those thresholds, it makes you TPI and you're subject to those restrictions instead of what's contemplated for non-exempt goods and services. And non-exempt goods and services can only cross the tiers if it's a flat fee. So if it's revenue based, it's percentage based at all, even if it's not above the thresholds, you can't cross the tiers. Next slide. Sorry if I took Charlie's slide there. As we touched upon earlier, there's out-of-state vertical restrictions. So retail licensees and TPIs can't hold any interests, including having goods and services agreement with supply side businesses outside of New York. And here, goods and services agreement it means both exempt and non-exempt, and essentially covers pretty much any type of agreement you can have. So there's really nothing that's going to, not be captured by the goods and services definition or the TPIs and the other definitions in here. So there's going to be limited ways to kind of work around some of these restrictions. One thing that did change in these recent round regulations is that the out-of-state vertical restriction no longer applies to TPIs of registered organizations with dispensaries. That's known as an ROD here in New York, and this is different from the existing registered organizations that are currently operating in the medical market. The RODs will be a new license that will be we expect to see, as Michelle earlier, sometime in the fall. Although I think this will be kind of one of the later license types that gets rolled out. On the next slide. So as we've been touching upon a lot, New York is set up as a two-tier market system, and there's cross-tier restrictions, meaning that you can't cross the tiers. In the revised regulations, a TPI and a registered organization under Article 4, meaning one of the two ones, not the existing medical operators, are now allowed to be passive investors in any number of supply-side New York businesses. Passive investor means kind of what you think it is. You basically are an investor that doesn't have any rights to control or any undue influence, and you have to fall below certain ownership thresholds, 5% for a public company, 10% for a non-public traded RO, and then 20% for a private company. Next slide.
All right. So now that everyone completely understands everything on how you can structure a deal and what's going on, I'll touch briefly on just a couple of other substantive changes. So one thing that did come out of these revised regulations is this concept of on-site consumption. So we always knew in the first draft that came out, essentially there was no mention of on-site consumption lounges. That was supposed to be a license type under the MRTA, but we hadn't seen it. And so what we are seeing is now some limited on-site consumption that will be allowed at retail dispensaries. So I'll spare you the long and short of how regulations are created, but essentially when you put out, first draft regulations, you can only do so many changes in second draft without having to go back out and do a full comment period. So the on-site consumption opportunities had to tie back into something that was already existing in the regulations. So they tied it back for existing retail dispensaries. So this is not going to be a standalone on-site consumption licensing opportunity. We're still waiting for the rules on what that license is going to look like, how you can do it. But the way they've kind of, as Elliot said, shoehorned it in is if you're an existing retail dispensary, which right now are the CAURD licensees, you would have an opportunity to do some on-site consumption, and you'd be able to designate an area, a distinct area within your premises. So if you happen to have found property, congrats first, and then after that, if your property that you found happened to have an outside area, they're coming up with a new name, limited retail consumption facility. It has to be inside the same building or in an adjacent parcel. So you can't say my smoking lounge is, 5 streets down, go left, go right, it's over there. It's got to be somehow physically tied either in the same building or in an adjacent parcel, but it does give some on-site consumption opportunities. And then they just do clarify, as they should, that it's still actually subject to the Indoor Clean Air Act. So you can't, consume cannabis inside anywhere with no restrictions. There are some limitations. And obviously municipalities still play a role here and need to authorize the activity. But if you can check all those boxes somehow miraculously, it does open up some opportunities to do on-site consumption. Next slide. All right, another new idea concept that is in the revised regulations, temporary cannabis events. So similar to on-site consumption, this is not a license you or I could apply for today. This is limited in nature to only existing licensees that already have it. I don't know if in the future there's going to be a pop-up license. I mean, to me, it's a possibility, but for at least this license, it says that certain licensees with permission are essentially allowed to squat on another licensee's property for up to 30 days. My crystal ball, given what's going on with CAURD licensees and the trouble finding property, should the 9 open CAURD licensees decide to be magnanimous and say, hey, other 290 who haven't yet found property, if you want to set up a pop-up in my store for 30 days, I'll allow it. So it's a temporary license that you can apply for. There's 4 pages of all the rules you have to follow in order to do this, but in a nutshell, lets you come on site for up to 30 concurrent days and operate your business, which also, given the on-site consumption possibility, if someone's got the magic golden property that has an opportunity for a consumption lounge, you as another licensee could try to strike a good deal, honoring all the TPI restrictions and all of the every other thing we've already talked about. But if you can figure it out, you'd be able to do on-site consumption, essentially at a competitor's location for up to 30 days if you can make those economics work. Next slide. All right, another notable change, this has been getting a lot of press. So for those that recall, the original draft regulations had a 3-year hold period for the existing medical operations, the registered organizations, in order to convert to adult use. And that was a 3-year hold from the first sale. So that was tied to the first sale occurred December 29th, 2023. So they were originally supposed to wait 3 years from that date in order to convert to adult use. The revised regulations say, you know what, we'll change that. You're at least allowed to open one co-located dispensary after that first adult use sale, which is where we get the December 29th random date. That was the date of the first adult use sale. So they will be able to convert one co-located store after that date, and then they can open up store 2 and 3 after June 29th, 2024. So that's been a big shift to allow their entry into the market. Next slide. I think this is my last one for a little bit. Just briefly touching on adult use conditional cultivators and their conversion options. For those that recall, the adult use conditional cultivator license was good for 2 years, at which point they need to convert to a full license. For those that were following along or did the math themselves, if you recall the first draft of the regulations, the options for conversion actually limited the conditional cultivators to less square footage than they have today. That was an oversight. The agency figured that out and changed it. So now there are expanded options in order to convert that are listed here. The square footage might not be ideal, but it does give some additional opportunities here. And then one other provision in the draft regulations that I think are relevant for the conditional cultivators and conditional processors, there is something in the regulations that say essentially if applications open up in the fall, whenever they open up, and if you want to apply for a full cultivation license, you can continue doing your current operations as long as you promise the state you'll surrender your license, if you get the big boy license. So under the cultivation and license caps, you wouldn't be able to have 2 cultivations. You can't have your conditional cultivator and your full cultivator, but under the rules, you can say, I want to trade this in, my conditional for my real, but I don't want to stop growing because this is a valuable license. So I'm going to apply, I'm going to go through the steps, and I promise state, if you give me the license I want, I'll surrender this license. So they give you that kind of parallel track opportunity, which I think is an acknowledgement that maybe you all might not be happy with your options for conversions. So you at least could throw your hat in the ring for the full license. Next slide. Sorry, trying to leave time for questions, going quick. All right, receivership. I will kick that over to my colleagues.
Yeah, so so the reason, okay, just big picture, right? Why does receivership matter, right? Receivership matters because if you don't have a specific section of the cannabis regs that addresses how to do the transfer upon sort of like a new court-ordered case, then you're going to have to follow the normal procedures, which can take a long time, right? We don't really know how long it's going to typically take to get M&A deal approved in New York, but it's a month-long process, multi-month process in a lot of states. So, for example, if a company's about to become insolvent and the creditors push it into receivership, if you wait those 3 months, let's say, the company's gone, right? Or, you know, in the case if someone dies, and you got to put the heir in as the owner of the company, same thing, right? Company can't survive without an owner for a long period of time. So, you know, we've seen a lot of receiverships in California. You started to see a couple in Massachusetts. And this basically just, you know, it's a mechanism by which you can do transfer. Now, the thing that's going to make it a little bit easier in New York versus, say, a California or Massachusetts is there is no local licensure in New York. And these receivership rules don't address local licenses because they can't. And the challenge I've seen has been that, you know, these local ordinances are not typically updated to address receivership because, you know, towns don't necessarily have the resources to like reopen, you know, their cannabis ordinance or any other ordinance they might have, you know, sort of on an annual basis to update it based on the state law. You know, the next one.
Next slide. And we're not going to dive into this, but just making sure everyone has a copy of the canopy tiers. They didn't change greatly, but you know, there's obviously huge differences in tiers and square footage, and want to make sure as everyone's contemplating and preparing the summer for applications to open the fall, at least on the cultivation side, to at least have the understanding and the exact numbers. And we don't anticipate these will change. Next slide. And don't fear, Elliot's got some technical difficulties, but he's trying to get back in. He will be available to answer questions. So I obviously put fun in quotes here, but just want to provide some additional information in case this wasn't on people's radar for this licenses. So if you're thinking about going for a nursery application, you first need to attain a nursery grow certification from the Department of Ag prior to getting a license by CCB. Not the Cannabis Control Board, sorry. So not exactly sure how this timing is going to work, but in terms of one of the questions about what applications are going to open up in the fall, the fact that two agencies need to figure this out and work together makes me think nurseries most likely not going to be the first license to open up in the fall, but just be aware that you will need an additional license for that. As well as another thing to consider just on the pesticides, you know, pesticides are the exclusive jurisdiction of the New York State Department of Environmental Conservation. So DEC, you know, if you're looking to apply any pesticides, you need to make sure someone is certified by DEC. So just making sure that that's on people's radar as well. And then just on the processor licensor, you know, it's kind of catch-all slide here. But a processor license is required for branding unless you are a processor TPI, including white labeling. So just making sure, and all of this going back to the state wanting to capture TPIs and who you're actually doing the work for and what's going on. So a lot of information that we just ran through quickly, but it looks like we've got a ton of questions in the chat and in the Q&A. So we're going to try to hop in and address as many as we can, with of course the disclaimer that, you know, if Charlie and Elliot's portions of the presentation didn't highlight enough for you, I'll say it now. This is incredibly complicated. It's incredibly fact specific. We're obviously waiting on some more details from the states. Charlie mentioned the forms. So, you know, definitely go talk with your own legal representation before acting on any of this information, but we can provide some, you know, general answers as we understand it. And with that long disclaimer, Charlie, you want to start picking some questions?
Well, I was just going to say also you know, you will receive a bill in the mail for any question we answer. All right, so well, here's an easy one. I think we addressed this one, but someone just asked about the slides and don't from that one. You're gonna get everything.
You can't pick that as the question.
I know. I just like that was an easy one. Let's start with slow, right? Just a reminder, everyone, like, yeah, we're gonna send this out to everyone afterwards, so don't worry. Let's see here if there's any. Can retailers from out of state invest in retailers in New York State without violating TPI? Yeah, I don't think that's an issue. Because you're staying in the same tier. And we got another question, right? Just to clarify, look, we're calling it the 2-tier. I mean, technically it's like a modified 3-tier model. So there is a distribution tier that sort of connects the producers and, you know, the consumers. But you can get your own, if you're on the production side, you can get your own distribution license only to distribute your own products. So you can't act as sort of like a, you know, wholesaler.
Yeah, and you know, with the caveat that you know, you can have an ownership interest in up to 3 retailers, and so yeah, out-of-state investment in retailer into retailer might not be a problem, but you know, taking a look at what that threshold for investment is, and making sure it doesn't trip any sort of license cap restriction on the retail side.
Can a dispensary charge membership or locker fees for an on-site lounge? Can there be different pricing for on-site consumption items?
I think for that, we are going to get a lot more information of what the standalone on-site consumption rules are going to look like in terms of what's permitted for the existing licensees. That's all in the regulations, and they don't have that level of detail. We expect that to be coming in further guidance.
Is there any update on hemp-derived, minor cannabinoids like CBN? Is this going to be addressed in the new hemp rules?
Yeah, so we have the existing framework about what hemp cannabinoids are permitted in the adult use market, what that process looks like, but in terms of any cannabinoids made through synthetic conversions, isomerization, we do anticipate the rules that are coming are more focused on the intoxicants, but for that don't have exact answer other than we do anticipate those draft regulations coming out in the next couple of weeks. I'd probably guess mid-June. So, that's the update, but tune back in for the actual answer.
Yeah, I was going to say, I had to jump away. Will there be a delivery? Yeah, will there be a delivery license? Yeah, there's a delivery license.
Yeah, and I'm just not sure exactly when these licenses, we know applications are opening sometime in the fall, but don't anticipate they'll all be opening at once. But as our slide indicated, as the regs indicate, there'll be 30 days notice before they go live on the website for application.
All right, what type of question should we go to next? We have a lot of open questions here.
How about, let's see, the public comments on the regulations are not on OCM's website. Where can we see them? Does OCM have to release the comments and responses as they did for other regulations? I can take this one. So when the regulations are posted in the state register, that's when they'll include the assessment of public comment. So as Elliot said, we do anticipate, given the cutoff deadlines for filing, that these regulations, draft regulations, will be back in the register on Wednesday, May 31st. And within that, there should be the assessment of public comment from when it's in the register, which is publicly available. You can sign up for them. They'll show up in your inbox, so you can read them there on the state register form, or OCM's been posting them about a week later. And it's not going to be, verbatim question and answer for all 3,500, but they will kind of aggregate them and say, we received a number of questions about X, and here's our response. So you should anticipate them either in the state register on or around May 31st, or they'll be posted on the state's website about a week later, so first week of June.
Okay, here's one. Can a retail dispensary sell its own brand in its store? It would seem they would need a processor license, and that process tiers would be prohibited.
So in the regs, I think the only branded products a retail dispensary can sell for the retail brand itself is cannabis merchandise. So that's not actually cannabis products, flower, concentrates. And the idea here, since the retail brands should be separate from the production brands, that the retail brands wouldn't sell anything outside of t-shirts and the like that have their brand on them.
Yep. So no house branded cannabis products for sale.
Yes, you think about like the kind of the liquor stores you see in the city. None of the liquor stores are selling liquor that's branded with the actual liquor store brand on it.
And then any merchandise you're selling with your own brand, which I just find an amusing fact, needs to be in adult sizes, any clothing. Sorry for those who've heard me say that before.
Yeah, so let's talk about white labeling agreements, right? We got a question about white labeling. It's obviously a big deal in all these different states. So if you're a brand from out of state trying to get into New York, what do we have? What should you be thinking about? I'll just start off by saying that it seems based on these rules that it's going to be tough to say that any kind of white labeling or co-packing agreement isn't a TPI if it's of any sort of reasonable size. Michelle, I'll let you review on that.
Yeah, and in fact, in the processor regulations, there's a regulation that says a processor may only enter into branding and white labeling agreements with its true party of interest or another licensee. Meaning, so, it essentially assumes that if you are a out of state brand that wants to white label into New York, you have to become a TPI or a licensee yourself. And based on our reading of the regs, it looks like a TPI in a processor could be a TPI in another processor. But we don't think necessarily more than two. So essentially an out-of-state brand looking to white label in New York really only enter into, what is a true branding white label agreement with two different processors.
Right, and then the big question that I can anticipate people then asking is, well, okay, if I'm a TPI in a processor in New York, how many of my shareholders do I need to disclose to the OCM? I guess this is where I start, and I'm being sort of optimistic here that they should really only care about the major shareholders, that 10% threshold, especially the TPI who's not actually a direct equity holder, but it's not perfectly clear to me from the rules how that will work. And then the other thing is, right, with these, TPI out of state is if you're vertically integrated in California and you have a brand that you want to sell into New York, you're just trying to think this through here, right? You would be a would you be offside of the retailer restriction? Potentially. The out-of-state stuff doesn't matter as much for a processor, but it matters more on the retail side. So I think you might be okay. That's something you'd want to confirm.
All right, I'll pick this one. So just came in. Does the conditional cultivator priority review of application include application for a cultivation license outside the transition option? So baked in, it does talk about the transition for the conditional cultivators, conditional processors, and conditional retailers being prioritized. Beyond that, it doesn't say there's any other prioritization for those license types, but it does say essentially, converting it to a full license we prioritize. So I don't think if you're likewise applying for a cultivation license, you'd be treated like all others. The prioritization only comes in for actually converting that license to a full license. All right, just looking through the questions, but if anyone else sees one. All right, one just popped. Any idea when CAURD licensees will get a second store open and what that process will look like? I appreciate people being ambitious and looking on to store 2 and store 3. So within the regulations, not just for CAURDs, but generally it says essentially if you're taking your existing application and looking to go for the exact same license of the same kind, same TPIs, same everything, the state will prioritize an easy copy paste for you. So you don't need to go back through the rigmarole of application. In the CAURD context, the state has said essentially let's get some threshold, some magic number that they seem to have in mind of how many for CAURD licensees are open, maybe 80%, maybe 90%, all open with store 1, but starting to think about stores 2 and 3. It's essentially a non-answer, but I'd say most likely you not be eligible to get store 2 or 3 open until of the 300 they're expecting to go out, a super majority are actually operational.
I'm just looking at some of the questions that were submitted directly to us that the others can't see. Does the town have the ability to prevent a licensee from on-state sales? As people may be aware, that the local opt-out deadline had already passed, and that was to opt out of both retail dispensaries and on-site consumption lounges. So if a town hasn't opted out at this point, they can no longer opt out, but they still can regulate time, place, and manner. And the revised regulations do specify certain hours of operations that are prohibited for both retail dispensaries and on-site consumption lounges.
And a question about the squatting rights that I mentioned. in terms of, a temporary event permit, as they're calling it. These temporary event permits are only they're only limited to the retail space at this point. For current operationals, eventually licensee would be able to, squat at locations for on-site consumption, retail, microbusiness, or ROD. So it's all on the retail tier, nothing on the cultivation side. All right, best guesses. How many licenses will be issued? Let's take a poll. Charlie, what's your magic number?
All the licenses added up together.
Yeah, for this first, let's say between October 1st and January, or yeah, and January 1st for this, we'll say first round.
The first round, I would say 2,000.
Oh, all right. Elliot, what's your prediction?
That's a good question. You know what? I haven't really thought that far ahead. Just trying to, understand the timing and when the rounds would open. But
No, say a number.
I would take the under of 2,000 though. I think based on what the OCM has been saying, they really want a kind of structured rollout and not to necessarily overflood the market. And try to keep the supply line kind of moving in an efficient fashion. And I think that means not kind of creating a glut of licensees at any kind of portion of each tier.
Yeah, and I would go under, but think that it would scale up quickly. But it's also, you got to remember it's the license portal, essentially the Business Express. So you got to make sure you can actually process it. Given the TPI forms they want everyone to submit, they have to actually review those and get it all done. I mean, they've been hiring staff, fast and frenzy, but they also still run the medical program. They still have hemp. That's a lot to get done. So I think 2,000 would probably be an aggressive amount. So my best guess is maybe like 500, 750 kind of this year, at least for this first round. And they've said there'll be, essentially several rounds, several phases, without actually putting numbers on any of that. All right, we've got a lot of questions about, along the theme of what documents are going to be required for applications. When should I start gathering them? Do you need property? So maybe Elliot, any thoughts there? If not, I can take it.
Yeah, I think as we've kind of been seeing, especially with the current CAURD license holders, a big gating item for all license types is going to be finding a suitable premise and location for your facility. Especially with the retail, there are certain setbacks and other requirements, and based on various people that we know, there are very limited locations that meet all those setback requirements in the city. Obviously elsewhere in the state, with more property, open spaces, there's likely to be more properties available that meet those qualifications. But we do think it's really important to try to lock down your location pretty early on in the process and lock that in exclusively to make sure it doesn't go to another licensee.
Yeah, and the provisional system would, not require property, but we don't yet know, if they're going to do a lottery or a ranking or how it's going to play out in order to award these licenses in this first round and future rounds. So we're not yet sure if property would be somehow prioritized, just given the fact that they want to accelerate getting everyone operational. Someone's asking
a bunch of.
Oh,
I'm sorry, go ahead.
No, you go.
There's a lot of questions about TPIs and the restrictions. So as we've been harping on, there's definitely the cross-tier restriction. Retail side can't go into the supply side and vice versa. But at a very high level, generally speaking, if you're TPI in the supply side, you can be TPIs and other licensees in that same supply side. So for example, TPI and a cultivator can be a TPI potentially in a processor and a distributor and the like. The amount of other licensees you could be TPI in, we think is limited to just one of each license type that's stated in the regs, but that's something that's not necessarily clear in the language. And then, people also seem to be still asking about the 10%, 50%, 250K rule. And so, we do see that as like a hard threshold, meaning that any person that goes above that would be a TPI. So, there's a question about if you have an in-house counsel, would that make this a salary greater than that? Would that make them a TPI? And based on a little read of the regulations, they would be. But there was also in the TPI definition, it pretty much lists that, any officer of the TPI of the licensee would also be TPI. So that's probably going to capture a lot of employees with high salaries and the like. And, and as we mentioned, us as a law firm, we have to be cognizant of those thresholds, because if we go above any of them, then we become a TPI. And to be clear too, it's the greater of 10% of gross revenues, 50% net profit, or 250K. So, currently everyone's just referencing the 250K because no one's really generating a lot of revenue or net profit. But going forward, it'll be the greater of, so that TPI threshold will increase, based on each licensee and how well they're doing.
And the assessment of public comment that should come out in a few weeks, usually provides a lot of insight into what the state was thinking, why they made certain changes and revisions. So something like that, often we'd see examples that might sweep up a general counsel or, another well-compensated position within a company. So taking a look at those should provide some more answers. And then of course, regulations is step one. Step two, we're going to get a lot more, FAQs, guidance documents, updated information from the state once these are, actually final, not effectively final, as we're calling them.
There's some questions about a micro business license, just to give a quick overview. That essentially allows for vertical operations, but it's going to, but you only limit it to the kind of one cultivation facility and one retail dispensary. And you have to kind of essentially be self-sufficient. The only kind of exception there is if for whatever reason you had trouble with your grow for a season, you are allowed to buy a certain amount of biomass from other cultivators, essentially to keep the rest of your facilities operational. But it's essentially a very limited vertical license, and you can't kind of have interests outside of your own vertical there.
And yeah, I was just going to add on the TPI thing, right? Like the 250K is a little bit unique to New York. I mean, most states don't have that sort of aggregate number at which you become sort of looped into the ownership system. Most states, it's sort of a percentage of revenue or profit. So people, and what they're trying to get at here is like these flat fee agreements that people have been using in other states to sort of, avoid being sucked into the orbit of ownership.
All right, and I know we have a lot more questions on this topic, and we would love to keep answering rapid fire, but I think our time is coming to an end. So a few people have also asked about other additional resources. We do post all of our videos online. We do put out a tri-state email newsletter, free. We put it out about every other month. It is tri-state, so you also get Connecticut and Jersey swept up with gift for purchase, purchase being no dollars. So if you're interested in signing up for that mailing list, it'd keep you abreast of a lot of this. We do put out a lot of blogs. We do have one on actually on the regulations, the rewrite, first draft, notable updates. So if anyone's looking to get up to speed on the market generally, and usually before applications open up, we do put some, 10 things to consider. We like our listicles. So there'll be a lot of additional resources rolling out as we get closer to applications, but we do anticipate everyone kind of taking the summer to prep their team, their property, figure out their corporate structure in anticipation of applications opening up after Labor Day. If you have any specific questions and want to talk to any of us further, you've got all of our email addresses, or we'll also be at CWCB at the Javits Center in June. We've got a booth if you want to stop by and chat, or if anyone's going to NECANN, Connecticut, I'll be there on Saturday speaking on Connecticut.
Yeah, and I was going to say, you just got to give us a little bit of grace here in the sense that some of these questions are hard to answer without any actual examples of how the regulators are interpreting things. And we also just got, these beast of regulations. And my experience has been dealing with this stuff in other states is that sometimes you don't really truly understand the regulations until you've been through at least a few kind of like gnarly examples of, how does this actually play out in person? So I would say, like definitive answers to all these questions, I would say by the end of the year, I think we'll be able to give you, answers to these questions that we'd be willing to, really hang our hat on. But I would just be skeptical of anyone who can, for the harder questions can give you sort of a definitive answer right now, because I just don't think that, enough information is out there yet.
Are you volunteering to do another webinar? That's what I took away from that answer.
We'll produce some content.
All right, well, thank you everyone for joining. Elliot turned into a black square because he had some technical difficulties, but appreciate that you're able to hop back on. All of this information, the PowerPoint and the recording will be sent to you after the fact, and apologies we couldn't get to all of the questions, but appreciate everyone joining us.